AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Welcome to You and the Law here on AM 650. Nice to have you along with us today, and we're going to talk about wills and estates and wills variation. Delighted to have back with us in studio David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver. David and Ian, welcome back.
Thanks, Sterling. Great to be here.
Ian, why don't you start? Tell us a little bit about yourself and your law firm, and then we'll get into the nuts and bolts of wills and all of that.
Well, I've been practicing law for about 25 years, all in Vancouver, and David and I formed this partnership about 8 or 9 years ago, and we have a small firm right across from the courthouse in downtown Vancouver, where we do a lot of estate litigation work and practice in a few other areas as well.
David, fill in a couple of the blanks here in terms of the work that Ian was talking about. First of all, tell us a little bit about yourself, but also more about the work that Hobbs Giroday does with respect to wills, because you don't, for example, do wills. You don't sit down and draw up wills with clients. Your work comes after that process. So tell us a bit about yourself and then more about the litigation done by Hobbs Giroday.
Well, Sterling, I'm a Vancouver person, UBC, and worked for several years in a large law firm, was a partner there, and Ian and I have worked together a lot for many years, so it's 30 years now, and now we're what I would call a specialized litigation firm where the emphasis is our estate litigation in our practice. And the people that come to see us are beneficiaries, they're family members, they're executors or administrators of estates, and generally they're having a problem or a struggle with an estate. Things are not going smoothly. Someone's passed away, and we're now trying to help them solve that problem.
Okay, and so the process, though, of drawing up a will is done by a different type of lawyer. You specialize in litigation of issues surrounding wills as opposed to preparing wills, correct?
That's correct. We don't draft wills. We interpret them, and we deal with problems that arise in estate matters.
Ian, I got a note from the good people at the Cancer Society about Legacy Month, which happens across Canada every May. And here in British Columbia, the Cancer Society, by way of getting my attention, had in large capital letters at the beginning of this promotional piece, 46% of British Columbians don't have a will. Ian Giroday, that is an absolutely astonishing number. How come so many, almost half the population of our province, that's millions of us, why don't we have a will? Why aren't we even that organized?
Well, I think other than human nature, I think the first explanation would be that it's probably fair to say that the general population doesn't get around to thinking about a will until a couple of things happen. One is that they accumulate some assets so that they have something to give under a will. Mm-hmm. But more importantly, adults tend to start thinking about a will when they enter into marriages, and even more so when they have children.
Right.
They have to start thinking about what happens if I die. How do I provide for my family?
And I suppose if you're a young 20-something invincible person, the prospect of even thinking about a will, David, is kind of creepy, and you don't even want to go there, do you?
No, I think you probably want to think about the Canucks winning a hockey game tonight more than you want to think about a will.
But nonetheless, and we find, and you people, particularly in your practice at Hobbs Giroday, come across situations constantly where there is no will and there is a deceased person and now there's an estate. And what happens, Ian, in the case where there's a wife and perhaps children, a person has died or maybe been killed, that person did not have a will, and yet there are those assets that you were talking about, and clearly there are children. All the reasons for the will are there, yet there wasn't one taken. So now what happens?
So what happens in that situation, that's called an intestacy. A person doesn't have a will. So the Estate Administration Act, a written law of British Columbia, dictates how those assets will be divided.
Oh.
And, generally speaking, they start with the act. The Estate Administration Act starts with the spouse. He or she will get a certain amount up front, not very much, and then will share the rest of the estate with children if there are children of the marriage. and then it can flow down to other descendants if there's no spouse or no children.
Now, David, you described your work earlier as you and Ian and your colleagues come in at a process or at a part of the resolution of an estate where someone has approached you because they think something is really wrong. It's just not right. This is just wrong. I need to consult some lawyers. This is not working out well. It's just wrong. It feels wrong. So in the event, though, where there's no will, and Ian has described now the state steps in and essentially dictates terms, now, in a case of a will where you represent people who are contesting a will, if there is no will in the first place, can there still be contesting of what the state intends to do, or is that just cut and dried and that's the end of it?
Well, a couple of issues come to mind, Sterling. One is even if there's an intestacy and no will, there still is the issue of the estate, and that means that somebody has to properly account for all the assets.
Sure.
And gather them up and see that they're distributed according to the legislation, and that the taxes and expenses are looked after and so on. So there are things that need to be done and done properly that can be not being looked after properly. The other thing is there can be an intestacy, but maybe there's an old will that somebody forgot about or didn't look for or don't realize exists.
Mm-hmm.
And so there sometimes can be issues regarding the question of whether or not it is an intestacy or there is a will.
But what if sorry to interrupt, but this just opens the door to so many possibilities. What, for example, what if you find an old will and the whole family's, oh gosh, we didn't even know this existed, but it was made 25, 30 years ago when the asset or the description of assets in that old 25-year-old will in no way represent the current accumulation and wealth of the individual who is now deceased. How does that play out, Ian, when you pull out, you dredge up this old document that's now officially the rule of the game?
Right. Well, if that will only refers to specific assets that no longer exist in the estate, then none of those gifts can be perfected, obviously.
Okay.
So that raises very interesting issues about whether the will have any effect or not.
Right.
It could be valid, but essentially ineffectual.
Because it doesn't relate to anything current.
Right. But there's a will there, and therefore you probably are going into a will's variation scenario.
Okay, now before we talk about will's variation, David, help us out and just take us right back to square one. What is a valid will in the first place?
Well, I mean, I like the word will. We tend to use it as a noun, the thing, the will. Mm-hmm. But when you think about it, it's really the intention or the instructions of a person. It's their will as to what they wish to happen.
Okay.
And it has to be in writing. Has to be signed by the person. They had to have capacity when they signed it, i.e. knew generally what they were doing. Has to be witnessed by two people, all at the same time. So these are all requirements set out in the Wills Act, and if you meet these requirements, then you have a valid will. And what does that mean? Well, it just means you have the instructions of a person that when they die, you follow these instructions as to how to deal with their estate.
What if an individual decides to be kind of a modern person and videotape their will? And so when there's, instead of the reading of the will in the lawyer's office, there's the playing of the tape. Is that allowed?
I haven't been asked that question before. I would say no. I mean, I'll give you an example. A holograph will is a handwritten will, but it's only signed by the testator, not witnessed properly, and so on.
Okay.
These are not valid in British Columbia. So generally speaking, you've got to meet the requirements of the Wills Act to have a valid will. If you don't meet those requirements, it's not a valid will. One exception would be a copy of a will. You can get a court to recognize a copy as opposed to an original in some circumstances.
So Ian, if you wanted to be Mr. TV and do that thing with the reading of the will on videotape, then what you would do is take David's advice and have a signed, properly witnessed document first and then read it on the tape, because then you're reading from the paper which can be produced as evidence. So you're basically just reading it into the record.
Well, it's essential. You have to have a written will. That's all there is.
And
to
all
it.
the other fancy stuff is just nonsense in the eyes of the court.
Yeah, there's one exception that doesn't come up very often, and that's the military.
Oh.
They're recognized in a special way in the Wills Act, and the requirements for wills for the military, i.e. the person dying in a war scenario is a special set of circumstances. So there is the odd exception.
Well, one would certainly hope for exceptions like that in the case of our serving men and women in the military.
Mm-hmm.
So talk to us a little bit. There's the parameters of a valid will. David, you've just described that it has to be signed and witnessed and this, that, and the other thing. So what then, Ian, are people complaining about when they show up in your offices downtown at Hobbs Giroday? They had a signed will, it was all properly witnessed, and here are the terms and conditions, and you deal with it as you play the hand you're dealt. And people show up and go, wait a second, I'm not playing this hand. I've been left out. I'm not even in the game.
Right. Well, really we're going to start down the path towards the possibility of a wills variation claim, but a will can be properly executed and meet all the formalities that are required under our Wills Act, but we have to make sure that the will maker had the capacity, the competency to make the will at the time he or she made it. And we also have to consider whether the will maker knew and understood the terms of the will. So a will can be invalid for reasons other than Wills Act formalities. So that's the first issue, because
the old sound mind and body thing, right?
Right, and we're looking at that because there may be an earlier will where the person who's coming to see us may have been treated to their satisfaction,
right.
Or it may create an intestacy where the person who has come to see us may receive under the intestacy. So that's the first circumstance we're looking at. The second circumstance is if all else fails and that's a valid will, the will that they come in with and where they're not happy with their either being disinherited altogether,
right.
or with the modest gift that they receive, then we're looking at the potential wills variation situation if they qualify under the Act.
Okay, now we've just had David define a valid will. So then, Ian, if you would please, what is a wills variation? What is that?
A wills variation is essentially a legal action that one can bring under British Columbia law, under the Wills Variation Act of British Columbia, whereby they can seek a court order to vary the will to their benefit.
Oh, okay. Okay, so they want an adjustment to the terms and conditions laid out in the will that they feel didn't include them. And in many cases, I would assume people come to you who weren't even named in the will, who feel really ticked that they weren't and believe that they absolutely deserve to be named, correct?
Well, they're either a spouse, a common law spouse, a child, but we meet estranged children, we meet adopted children, we meet children that no one ever knew they were the children of
right.
the deceased and so on.
Right.
But if they meet the test of spouse, common law spouse, or child, then they're a potential claimant for wills variation.
Okay, so a wills variation then, David, people applying to the court to have sections of a will overturned or varied, is it a very specific limited list of individuals who can apply for a will variation then?
Well, it is. It's as David had alluded to, it can only be a spouse, a common law spouse, or a child, and a child is either a natural child or an adopted child, not just a stepchild that's not adopted.
Not even a favorite niece or nephew? That's one relative level too far away?
And not even grandchildren.
Interesting. So there is a limitation. There is a very finite group who can apply to have a will changed or varied.
Right.
When you think about it, Sterling, though, in a typical situation, who are the people closest to you and most likely to receive part of your estate? It's
Sure.
your spouse and your children.
Right, right.
And that's what the Act is. It's addressing that group.
Interesting stuff here today on You and the Law here on AM 650. Ian Giroday and David Hobbs from Hobbs Giroday in Vancouver. We're talking wills and estates and variation, and it's just beginning. Lots more ahead. Stay with us.
This is You and the Law. There's more of the show still ahead on AM 650.